On January 26, 2024, bullhornbetty filed plaintiff's response to defendant's memorandum in opposition to bullhornbetty's motion to dismiss first amended counterclaims. This video will be the reading of that document. Comes now. Plaintiff, bullhornbetty, acting as pro se in this action, files this plaintiff's response to defendant's memorandum in opposition to bullhornbetty's motion to dismiss the first amended counterclaims, for grounds stated as follows. Background. On or about October 18, 2023, bullhornbetty, BHB, served queenbee, QB, with an amended complaint alleging defamation, tortious interference with business prospective economic advantage, intentional infliction of emotional distress, civil conspiracy and concert of action, negligence and unjust enrichment. QB caused damages to BHB for over a year. BHB did nothing to justify this outrageous and detrimental campaign of bullying, stalking, harassment, and other damages that QB knowingly inflicted on BHB for no other purpose than to cause damage to BHB for monetary and other gains and/or benefits realized by QB. BHB has alleged, among other issues, that QB has conspired and communicated with others through private chats, such as Discord and other similar sites, to elicit help with QB's campaign of harassment, cyberstalking, bullying, and intimidation to receive financial compensation, to damage BHB personally, professionally, financially, and to remove BHB from the YouTube platform. On or about November 2, 2023, defendant QB filed a motion to dismiss the amended complaint citing conflicting law, which is at issue in this matter. On or about December 29, 2023, the defendant filed two motions. 1. Reply in support of QB's motion to dismiss under Section 2-619.1 of the Code of Civil Procedure, and 2. Memorandum in opposition to BHB's motion to dismiss, first amended counterclaims. Introduction. Defendant had a valid one-count complaint. BHB and QB were before the court on October 2, 2023. The order of the court denied 2 of the 3 counts of QB's counterclaims with the right to amend after BHB filed BHB's first amended complaint, FAC. QB survived legal scrutiny on 1 count of defamation, per se. On or about November 8, 2023, QB elected to amend counterclaims and propounded defendant's first amended counterclaims, FACC, upon BHB to include the original abuse of process count that was originally denied because BHB moved the court to amend the original complaint and the court granted the plaintiff's motion. On or about November 26, 2023, BHB filed BHB's motion to dismiss FACC alleging QB's FACC cannot survive legal scrutiny on similar grounds as originally pled. On December 29, 2023, QB took issue with BHB filing the motion to dismiss with arguments similar in nature as BHB's previously filed, which was granted in part. QB alleges among QB's arguments yet another step in BHB's intimidation and harassment campaign, running up legal fees against someone who had the gall to criticize her behavior. Argument. It is well established in Illinois law that if a litigant amends their pleading, it effectively starts the litigation process over. Here, the courts gave QB the option to amend QB's counterclaims and preemptively granted that motion should QB elect this option. Once QB modified the original counterclaims previously accepted by the courts, it is as if QB propounded counterclaims upon BHB for the first time and starting the clock over. The court did not hear arguments on the abusive process because the court acknowledged BHB did not have valid complaint due the motion for leave to amend complaint that was granted by this honorable court. QB's original complaint consisted of 3 counts, whereas QB's FACC only consists of 2. The original complaint and FACC are substantially different. Whether or not the arguments are similar or not, QB chose to amend QB's counterclaims and therefore, Illinois rules of civil procedure apply, which entitles BHB to challenge the legal sufficiency of the newly refiled FACC. QB is knowledgeable of this established legal standard, yet chose to file a 15-page memorandum, once again attaching confidential good faith settlement negotiation communications into the public record, running up QB's own legal bill. BHB has met her standards necessary to dismiss this action under 735 ILSC Section 2-615. QB failed to state any cause of action which relief may sought or granted for the reasons set forth in BHB's motion to dismiss FACC. Conclusion. Now, therefore, Plaintiff, bullhornbetty, requests this court to grant plaintiff's motion to dismiss first amended counterclaims. Respectfully submitted. By bullhornbetty. BHB. aka bullhornbetty. Pro se plaintiff. Certificate of service. Undersigned certifies and states that on January 26, 2024, plaintiff caused the foregoing document to be filed using the Odyssey e-filing system. That same plaintiff caused a copy of the same to be served as indicated below. Queenbee's lawyer. Just a reminder, I am not a lawyer and I do not claim to be one. This concludes this filing BHB made with the court on January 26, 2024. Let me know your thoughts in the comment section. Thank you to my members. Your support means the world to me. Please smash the like button, comment and subscribe. I will see you next time.